I am going to discuss new hire documents. And so there are certain documents that you need to provide to your employees at the time of hire. Those will include the I-9 employment eligibility verification. And remember, the I-9s did just get updated, so be sure you are using the most recent one. Prior to this year, it was a very old I-9 form. So be sure that you are looking it up, making sure that you are getting them directly from the government website or the state website, depending on which forms you're looking at, to be sure you have the most current form. You also will be needing to give your employees a W-4 federal and DE-4 state tax withholding forms, the Labor Code Section 2810.5 wage and employment notice to employees. And an important thing to note about this, two things. One, which we will discuss a little later, is the increase in paid sick leave. So there is a section on the Labor Code Section 2810.5 form that talks about how much paid sick leave the employee gets. You want to be sure you are updating that to comply with the new law, and also checking your local ordinances to be sure that you are complying with that as well. Also, a legislation that passed in October is a requirement to include a notification regarding disaster relief. And we'll talk about that a little later, but you do want to be sure that you are looking at that. The forms with that box will not be released until later next year, but something to keep an eye out for. The workers' compensation time of hire pamphlet, that includes the personal chiropractor or acupuncturist designation form and personal physician designation form, as well as the sexual harassment pamphlet, which is the DFEH 185P form, EDD disability insurance, paid family leave, harassment, discrimination, retaliation, prevention policy, and confirmation of receipt, and lactation accommodation policy. These last two policies are often in your handbook already, but we do recommend that you have a acknowledgement and receipt that is separate from the handbook that can easily be pulled outside of just the acknowledgement of the general handbook to show that they received those specific policies. The other documents include the rights of victims, domestic violence, sexual assault, and stalking notice, as well as the new health insurance marketplace coverage options and health coverage, general notice of COBRA. And if an employees are minors, be sure that you have their work permit, as well as if you have a commission employee, you have a written commission agreement that includes the specifics on how commissions are calculated and paid. And you want to be sure that you're giving copies to the employee and employer. So these are kind of the required list. There are others that, we recommend that a lot of employees do give with their initial hire, including, including emergency contact information and things of that nature. And one question I wanted to address here real quick is someone was asking, in a situation where there are many forms that weren't signed when our employees first started, such as the notice, the 2810.5 or meal waivers. If we want to become compliant, if we want to start being compliant by having all paperwork up to date, does this remove any liability of non-compliance in the past? Unfortunately, that liability can still exist. However, it is important, if you don't have these forms signed and up to date, that you do get up to compliance. It can help in defending any potential lawsuit, and it can help you show that we did become compliant as of this date, and be sure that you have those forms, especially some of these forms such as the I-9 that's required by federal law. Many of the mandatory forms must also be given to the employee in their primary language. You want to check local and city county requirements. For example, if you're in the city of San Diego, there's a acknowledgement and receipt of the earned sick leave and minimum wage form. And you want to be sure you're filing the new employee reports within 20 days of hire, which is the DE-24, and reviewing your hiring documentation to be sure that there's nothing else you need to include. I'm going to very briefly go over a couple points for employers who do conduct background checks. There are a couple of things that you do want to keep in mind. There are a list of required documents pursuant to both the Fair Credit Reporting Act, which is the federal act, as well as the Investigative Consumer Reporting Agencies Act, which is the California Act. Under the Fair Chance Act, it was extended in October 1st of 2023 to require an employer to consider evidence of the applicant's or employee's rehabilitation or mitigation circumstances, and employers have to conduct an in-depth analysis using new evaluation factors before making an adverse employment decision based on criminal history. You also want to be sure you're checking local ordinances. The city of LA, as well as the city of San Francisco, have their own ordinances regarding background checks. So these are some of the factors that employees are required to consider under this expanded Fair Chance Act, and that includes the specific personal conduct of the applicant that resulted in the conviction, whether the harm was to property or people, the degree of the harm, the permanence of the harm, the context in which the offense occurred, whether a disability, including but not limited to past drug addiction or mental impairment, contributed to the offense or conduct, and if so, whether the likelihood of harm arising from similar conduct could be sufficiently mitigated or eliminated by a reasonable accommodation, or whether the disability has been mitigated or eliminated, whether there's any trauma, domestic violence, dating violence, sexual assault, etc., or similar factors, the age of the applicant, the amount of time that has passed, when the conviction led to incarceration, the amount of time that has passed since the applicant's release, the duties of the job, whether the context in which the conviction occurred is likely to arise in the workplace, and whether the type or degree of harm that resulted in the conviction is likely to occur in the workplace. The Civil Rights Department has a lot of sample forms, and if you go to their website, you'll see under the Fair Chance Act, they have samples of the compliance statements, your conditional job offer. Here's a sample criminal history individual assessment form that all can be found on their website. Now, these are additional recommended documents that we recommend employers provide to employees at the time of their hire, and that includes the employee handbook and obtained signed acknowledgement of receipt, the arbitration agreement that Benita talked about earlier, any orientation or training documents, confidentiality agreements, direct deposit form, and other job-specific forms. One item that used to be on this list were non-compete agreements. However, SB 699 and AB 1076 were just passed in October by the governor, which essentially prohibits employers from entering into or attempting to enforce non-compete agreements. So it's really important that coming up on the new year that employers are reviewing their agreements to be sure that there's no non-compete or restrictive covenant that does not comply with this new law. It may be something that's embedded in your confidentiality agreements or non-solicitation agreements, but you are still able to protect trade secrets or proprietary information. So something to consider on maybe reworking those agreements, and you want to be sure you are reviewing those documents. We also recommend that you provide an offer letter that includes the at-will designation, description of the job, integration clause, submission of terms, any confidentiality provisions. And you do want to be careful of choice of law provisions because employers are prohibited from requiring employees from adjudicating claims outside of California. So we're going to skip over this in the interest of time, but you do want to be sure if you are employing minors, you do obtain all of this information. You're getting their work permits, that it's up to date. You're following their overtime rules, the number of hours they're allowed to work, what they're allowed to do, especially in the restaurant industry. There's certain tasks and that minors are not allowed to participate in. So you do want to be sure that you are checking those and make sure the minors are aware of what they can and cannot do. There's different hours they can work, whether they're in school or out of school, depending on their age, whether they're emancipated. All of those factors come into play.